Okay, this is what I'm going to do. I see that you're not appropriately dressed for court. So what I'm going to do, I want you to stay logged in. I'm just going to stop your video because
Okay.
you did inform the court clerk that you did not have the appropriate attire. However, I'm still going to allow you to attend this hearing, but
Thank
it's
you.
going to be appropriately. All right?
Yes, sir. Yes,
Okay.
thank you.
All right. With that being said, let's do this. Before I do that, let me go ahead and start your video again, Ms. Ramos.
During the court proceedings, the judge addressed the issue of the defendant not being appropriately dressed for court. Despite this, the judge allowed her to remain present in the hearing, but turned off her video to maintain courtroom standards. The session proceeded with both parties being sworn and under oath to ensure truthful testimony.
Ramos.
Okay.
All right, let me get both of you to raise your right hands. Do you solemnly swear and or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Okay, all right. So now I'm going to go ahead and stop your video.
Okay.
All right, so today we are here. It's an eviction suit. Cause number is J2V26-0096. Branch versus Yolanda Ramos. Change to the address in question, 817 Call Court, Waco, Unit 22308, Waco, Texas 76708. At the last hearing, you, Ms. Ramos, swore to the court that you were in the process of moving out and that you needed additional time to complete the move out procedures. At that time, the court did give you so many days to honor what you stated to the court under oath before proceeding on with this case.
Yes,
And
sir.
so I'm going to start with you, Ms. Ramos. Did you do what you swore to the court you said you were going to do?
I was out within the 24 hours, and we didn't get the paper signed. I called. I just left over there again, and she's never returned the phones.
Ms.
to get the
Ramos, what
Okay.
paper signed? There was nothing for her to sign.
No. I'm sorry, Your Honor. The payment plan agreement.
That had nothing to do with this case.
Yes, sir. I did. I did.
The payment plan is something that you and the apartment complex can agree to after you did what you said you were going to do, which is give up the rights to the property.
Yes, sir. I did.
Listen to me. How and when you pay, that's purely up to you. They don't have to agree on a payment plan.
The case concerned an eviction lawsuit filed against Ms. Ramos. The judge reviewed the previous hearing, noting that she had promised under oath to vacate the property within a given time frame. However, questions arose regarding whether she had fully complied with that commitment, particularly concerning the return of the property keys.
Yes, sir.
Now, let me ask you this, Ms. Ramos. What's your new address?
I don't have it.
What's an address you can use to receive mail?
My mother's.
And what's that?
3517 Maple Avenue, Waco, Texas, 6707.
That's 3517 Maple Avenue,
Yes.
76707.
Yes.
Did you give the keys up to the property, Ms. Ramos?
I totally forgot about it, and I thought we needed to talk about the payment plan. And when I went yesterday, I forgot the key, and I have the key now, but I just left her office. There's one in the car, and I got the other one. And I thought I made a mistake. I thought we have to do a payment plan, and then she says that we got to give the key up, and then she'll do the payment plan with me. And I just left her office, and she was not there. It's hard, sir, because I don't have a car. My stuff in the storage, and I can't get to my clothes, so it's like hard to get in there and in and out. And I wanted to ask you if may I, because this is all new to me. when I surrendered, it was, at a distress, because I have other documents that I wanted to do with the eviction, but I didn't know how to bring it up to, why.
Miss Ramos explained that she had moved out within 24 hours but failed to return the keys, citing confusion about a payment plan and difficulty coordinating with the property management. She also described personal hardships, including lack of transportation, storage issues, and health challenges, which complicated her situation.
The reason why I was evicted, she says, for disrespecting her, and all I wanted was my right rent, because the lease, the first lease, she never gave it to me till I had to call the manager, Misty Hernandez, in the region, and she sent me that lease. Sir, none of that's correct. All that was lies, and it's her handwriting. She had me in 2101, not 2308, and she ignored my disability. She overcharged me, and then all that overcharging, when she says that I didn't qualify to be where I was at. So I don't understand what made it different. 3 leases that we came to the agreement of the truth was through the program. It was 445, and I want to know why she said that. She made an income line, said that I had $500 extra. Why would she tell me that to get in there? Which now I don't have the 500 that she wrote down, and I'm still in the same spot. Why all the numbers? Why all the fraudulent numbers? The amount, and I get evicted for something. I'm asking why, and she says I didn't understand the program. But you changed it 3 times. If I was wrong, why did it change to 445? And it wasn't that from the beginning. Why was I placed on 3rd floor when I'm disabled? I have rheumatoid arthritis.
Additionally, she raised concerns about alleged misconduct by the landlord, including incorrect lease terms, overcharges, and failure to accommodate her disability. The judge clarified that such matters fall outside the court scope in this eviction case and should instead be directed to the appropriate housing authority.
I have documents, and she's seen it. My lungs are messed up. I'm really sick, but I had to grab my stuff, and it messed me up worse. And I want to ask if this is possible. I'm going to make it quick. Is there any way that I could ask for an audit to prove that she could be wrong?
Okay, so here's what I'm going to encourage you to do, Miss Ramos. All right, the questions that you are asking, these questions need to be directed to TDHCA, not the court.
Which they already have.
Okay, so with that being said, it's TDHCA. That's the entity that will determine whether or not your landlord did something wrong in accordance with the rules and the procedures that they set forth. Now, Ms. Ramos, the court did give you the opportunity to do something. And that's something that you had swore to me that you were going to do. All right. Now, here's the thing, Ms. Ramos. At the last hearing, Branch did prove their case by preponderance of evidence. They proved that they gave you a notice to vacate. They proved that you defaulted the lease. All right. There's going to be a judgment placed against you. It's just going to be for property only. Okay. And court costs. It's going to be for property and court costs. Again, like I told you at the last hearing, whatever back rent that you owe is still going to be reported to housing, and you will still have to pay that. How and when you pay it is purely up to you. But until it's paid in full, housing will deny you any further assistance. You have 6 days from today's date to appeal my decision for ruling in favor for the plaintiff. Appealing my decision means you disagree with my decision and you want your case heard all over by another judge at the McLennan County Court of Law. In order for you to appeal this case, you would have to give me a cashier's check or money order for $890. If you cannot afford that, I strongly encourage you, again, I say strongly encourage you to contact someone from Lone Star Legal Aid. And this is only if you cannot afford the bond and you want your case heard all over again by another judge. You have 6 days from today's date to do so. If you do not successfully appeal this case, and when I say successfully appealing, means that either you post a bond or you get help to appeal. If you don't do either of those within the next 6 days, then at that time, you will probably be served with another notice to move out by the constable, and that's just 24-hour notice.
I don't live there. Everything's the house. I got pictures right now. I took pictures.
But you have not turned in the keys. I told you at the last hearing, all you needed to do, I told you at the last hearing that in order for you to give up your rights, you need to give up the keys to the property and write a letter, just a letter saying I give up my rights to the property, not a payment plan.
No. But sir, what do I do with the key? There's not even a drop box. She's never there. I got emails where I wrote her and I asked her to call me, and she never ever answered me.
Well, the only thing I can tell you is that until you give the keys up to her, then if you don't give the keys up to her, then that's fine. But if she refuses to take the keys, leave them with someone there. That's all I can tell you.
But
all right.
Is that why I lost because of that? Because I got pictures. I don't live there. I took pictures. I cleaned it up really good.
You have not given up the keys to the property.
Okay, so when I give it, I still got to pay the $800.
Listen. Now, okay. Let me say this again. There's going to be a judgment against you for court costs. You got that part?
Yes.
Okay.
Yes, sir.
The rent that you owe will still need to be paid, but it will not be a part of the judgment. You got that part?
I don't get it.
Okay, let me say this again. The rent that you owe, Miss Scoggins, is more than likely still going to report it to housing as delinquent rent. Okay? Am I right, Miss Scoggins?
I would if she was on housing, but she's not on housing.
She's not on housing any longer?
She's never been.
She's never been on housing?
No.
Tax credit property. I mean, we accept here, but she does not have a Section 8 voucher.
Okay. All right. So with that being said, there's no one to report anything to. So you just need to pay the judgment, which is the court costs. Now, with that being said, if you want to appeal the case, meaning that if you disagree with me ruling in her favor for possession and court costs only, then you would have to pay $890. Ma'am, if you cannot, again, if you disagree with my decision,
I understand.
If you disagree with my decision, you either pay the $890 or you call Lone Star Legal Aid.
And I'm gonna lose my car.
Your car, man.
They evicted it. She never played. When I called the tow people, the rapid recovery, they said I was never even registered at all. And I've lived there for 7 months.
Miss Ramos, this hearing has nothing to do with your car.
It's coming up and I don't have any money.
If you filed a case, then you have to wait on to that day before you can talk about that case.
They just emailed me on your deal, Erica, and it's connected to your account.
But listen, that tow hearing that you're talking about has nothing to do with this eviction. You still will get the opportunity to prove to me why you feel like your car was towed illegally or unauthorized. That is later. That is not today.
No, but I lost this one, and I'm telling the truth.
The reason why you are having a judgment placed against you is because you did not fully comply with your statement that you were moving out and giving up the rights to the property. That's the reason why.
It's her. She wouldn't even answer my calls. I got proof of it.
I've heard it.
Ultimately, the judge ruled in favor of the plaintiff, granting possession of the property and assigning court costs to Ms. Ramos. She was informed of her right to appeal within 6 days, either by posting a bond or seeking assistance from legal aid. The judge emphasized that failure to comply could result in further enforcement actions, including a final eviction notice.